Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's episode is What Can AI Do? Examining the possibilities of using artificial intelligence in the law. It seems like every day we hear more and more about advancements in artificial intelligence, and they are affecting our lives in all kinds of different ways. But a fascinating question is, how, if at all, will it affect the law? Now, we see AI touching the edges of our practices. Things like doing document reviews and searches for relevant material and even working on contracts. Some of that is beginning, but what's the next level? And how far can this ultimately go? Today, we have a guest who has been doing a lot of thinking and on this topic, and we are looking forward to learning more. My co-host today is Kayla Odom. Hey, Kayla.
Hi, John.
Kayla, what are we doing today?
Well, as you mentioned, the use of artificial intelligence is spreading rapidly around us. And with that, people have begun to look at how we can utilize AI in the legal system. But as we think about where AI could go, it's worth taking a step back from a theoretical perspective to really understand what AI is and what it's even capable of. We're always looking for efficiencies, but with the law, we're also looking for fairness and just results. What are the possibilities? What are the ethical considerations? Should we be concerned?
Yeah, and I'm a little worried about the Terminator scenario, so I want to learn a little bit about that. Well, who's our guest today?
Our guest today is Josh Davis. Josh wears many hats. He's a professor at the University of San Francisco School of Law, the director of the school's Center for Law and Ethics, and was previously the school's associate dean for academic affairs. He's done empirical work and written extensively on antitrust law, complex litigation, and ethics. And he's also worked in private practice. In recent years, his research has taken him to explore artificial intelligence and particularly how it might play a role in antitrust law. Josh, it's great to have you on the program today.
It's great to be here. Thanks so much for having me.
Great. So at a fundamental level, how would you describe artificial intelligence?
So this is a really hard question. I'm going to give a relatively, I hope, accessible answer, but I think, and there's a lot of dispute about it, just so you know. But having said that, people tend to define artificial intelligence as doing the kinds of things that people can do, and historically that only people could do. And so, you think about computers and litigation today. You talked about document review in the introduction. That's something that historically only people could do, looking for responsive documents. And so that fits into a very large bucket of artificial intelligence. Sometimes when people talk about artificial intelligence, they really mean machine learning, which is a machine changing its own program over time. And in a sense, in a very loose sense, maybe getting smarter. So sometimes, it's a great question. It's a hard one to answer because people use the term artificial intelligence differently in different contexts. Sometimes when people say artificial intelligence, they mean as smart as a person in every way, which sometimes is called artificial general intelligence. And but I think it's best that sort of, those are deep waters that we'll get to, I'm sure, in a minute. And I would just say doing the kinds of things that traditionally human intelligence was necessary to perform, even if it's a narrow task like document.
So you talk about machine learning. How do we get there? Like, where does the data come from that the machine can learn from, I guess?
Yeah, so it's such a great question. And the answer right now is it comes from us. So if you think about kind of the progression of artificial intelligence, let me just take a minute and describe kind of 4 stages. We are in stage 2, and we're still really stumped about stages 3 and 4. Stage 1 is just deduction. We have to give the rules to the software, the hardware, but the software really, and then we have to give it information so it can apply the rules in a mechanical fashion, and then it's off to the races. And that turned out to be really limited. That was the main way artificial intelligence worked, arguably through the 90s. Now we're in the big data era. And in the big data era, we move from deduction to induction, statistics on steroids. Now, we still have to do a lot of the work. We still have to provide the data. We still have to tell the computer how to categorize the data. What attributes of the data are you looking at? How do you find them? It has to be very mechanical. But now, big data, now computers can do that. And they basically can draw inferences from data in patterns that we may not see. Some of them are very surprising and powerful. Some of them are disturbing. In one finding that's relevant to this piece is there was a researcher who applied this statistics on steroids, this big data approach to photographs on a dating site. And lo and behold, in a way that he couldn't himself understand how, it was able to determine which men were straight and which men were gay just by their photographs, which is in some ways stunning and powerful, and in some ways horribly frightening, right? But what's crucial is that data had to be packaged for the computer by the researcher, and the questions to be asked had to be formulated by the researcher. What kinds of things might you be looking for? The computer was very passive. The next two steps, one has a fancy name, which is abduction, which you could just think of as common sense. Right now, people have no idea how to program computers, a very limited idea how to give it common sense, how to give it any kind of judgment. So if you're talking about a document review, we have to tell it, look for these things. We have to tell it, break down, this is how you should be looking at patterns, look at words, look at whatever it is. It has no common sense about that. And so all of the little decisions, what data to look at, what considerations to take into account in trying to, and looking at the data points, all of that, the variables, we have to give it. And then the last step, which is really getting deep, would be making value judgments. You might call it end or objective formation. And really, technologists have no idea how to get a computer to choose what it should try to achieve. They're at ground zero.
So we provide the information, and AI has the ability to analyze and interpret it. And you're saying make judgments based on the information, judgments we might not even think of.
Well, so this is, we want to be careful. It doesn't really make judgments. I mean, that's part of what's scary. It's not making judgments. It's just going to see patterns. Okay. If we say, hey, look at sexual orientation and look at the pixels in these pictures, it'll give us all sorts of information, but it has no ability to exercise judgment. It has no ability to say, oh, I can tell you who you should hire, but we can give it the data and ask it who's likely to be promoted, who's likely to get a pay raise. And it'll tell us, and we may think that that's telling us who the best employees are. But actually, the data may embody history of discrimination by sex or by race or by socioeconomic class. And it's not going to exercise any judgment on its own. It's not going to say, hey, you may want to take this into account too, or see these results have a big bias. It's not going to tell you that. It's not going to tell you whether a bias is good or bad or indifferent. It can't do any of that. And we are not sure it will be able to do any of that.
So it sounds like it's not going to completely replace us.
Well, so that's the question. I don't know. I mean, my reading to date, there's some wonderful recent books on this. It makes me think that there are two leaps that we're waiting for that may never happen. One is exercising judgment or intuition or those sorts of things. AI is really struggling with that. It's all brute force. We have to kind of send it in the direction we want it to. I mean, John, you had mentioned Terminator early on and the fear of that. And I think that is pretty distant if it will ever happen, because here's the scary thing about the Terminator. The Terminator is AI with a will of its own. We have no idea how to give AI a will of its own. The fear right now, the primary fear, it should be the rule of unintended consequences. It's sort of be careful what you wish for, because we might instruct AI to do something, And it may go wildly off the rails if we haven't formulated that request carefully. And if we haven't monitored it, we may not notice. That's the fear.
AI is also not capable of emotion or judgment. It's like if you ask somebody you could ask somebody to do something and they'll keep doing it, even if the, repeating that same thing somehow becomes morally wrong. Right. Or it will make a judgment. And it may decide, look, if we take this step, it may end up killing a certain number of people, but for the overall good, that's the better judgment. And I think that's the part that makes me a little bit frightened, is where we kind of leave that with AI to do.
I think that's right. I mean, so that's true for now. And there's two things I want to separate. One step is it may be that AI at some point has some capacity for common sense, not in terms of the objectives that you pursue, but in how it should go about doing that, right? It's still instrumental reasoning. It's means, not ends. Then the next leap forward is, can it actually recognize something's immoral on its own? And that, I have a book forthcoming, and that book in part is arguing that in order to arrive at that step, AI needs to develop consciousness. And I wouldn't rule that out as a possibility. We just have no idea how to do that right now. And if you want to talk about it, that's sort of a really sort of distant future AI. And there are three main routes that I think may take us to conscious AI that we need to contemplate. But and so I'm happy to talk about how that might look if you really want to go in that distant way. But I do think that's distant and speculative. It may never happen. On the other hand, it may happen. I wouldn't rule it out. Technology has a habit of surprising us, as some folks in this industry like to say. We overestimate the change that will happen in a year, and we underestimate the change that will happen in a decade. So who knows what's coming around the corner?
As we start to think about how we could use, I guess the current level of AI, how can we use what we know about AI in the legal system? And is it even, ethical or moral to do that? Or I guess where could AI best be suited for use in the legal system that we're currently not seeing, but where's an area for improvement?
Sure. So it depends on tests, but I think that there's lots of areas for improvement. I do empirical research in antitrust, and I try to use current AI to cull data about private antitrust cases to see what happens, what were outcomes on motions to dismiss, motions for summary judgment, all that sort of thing. And the project has been successful, I'm happy to say. I'm sad to say that the AI wasn't capable of doing what the purveyors of this particular AI promised. It was more like artificial stupidity than artificial intelligence. But we had to hire a bunch of law students and recent law grads to go in and code. So what I think we'll see in the next step is AI being much more effective at the brute force tasks that it is capable of doing. And that would be things like predicting the likely outcome in a case based on objective criteria that we select, and maybe finding surprising patterns along those lines. There may be things that we don't normally pay attention to, at least not explicitly, in predicting what a case is worth. And I'll give you an example. Let's say you've got a private antitrust case. It may be, and this is speculative, I don't know this to be true, it may be that the sheer number of cases filed by private lawyers and the sheer number of plaintiffs' firms that are involved is highly predictive of the size of the recovery. No one's ever looked at that empirically, but that's where AI might be able to detect patterns because it is statistics on steroids. That'd be fascinating, right? If you can imagine defense lawyers saying, look, we've run the AI. We don't need to look at the merits at all here. Just look at how many firms were drawn into this. There's a clear consensus among plaintiffs' lawyers. This is a good case. We know this thing is going to resolve at over 100 million. It's just, it always, the odds of that happening are really high. So that's the kind of thing it may be able to do in the future. There's actually a law in France that stops use, at least tries to stop use of AI from predicting outcomes in cases based on the identity of the judge and characteristics of the judge. But that may happen. It may be you plug in certain things about a judge. What was, say, in the U.S., what was the political party of the judge, of the president appointing a judge? What did they do before they became a judge? And that is sort of scary, but maybe that could really predict outcomes. The other stuff that we're seeing now that may get much stronger is the sort of the document review stuff, maybe legal research, where AI can become more powerful and help identify all sorts of cases that you should be looking at based on some of the cases you're already using or based on a fact pattern even. Those are places I think we might be going.
And it's interesting. It's actually a tool that would help settlement an awful lot. Mm-hmm. Because the problem that I think that comes up when you try to settle a big antitrust case is generally it's obviously there are information asymmetries. So let's put that aside for a moment. But the biggest problem is generally that people are looking at the strengths and weaknesses of the case in different ways. And if you could have an AI, in some ways, that's why we bring in mediators, retired federal judges who use their experience to tell us, okay, well, this is where I see the case coming out. And it's good. But if you could have an AI that could really help you with that, I think that could be really useful. And the other thing is you think about the simulated and settlement is you think about at the beginning of the case, all of the different branches in the decision tree that you would have to get. It's very hard to keep track of, but perhaps not somewhere where AI could help.
That's exactly right, I think. And I would actually say, generally speaking, I think there's three things that are related that prevent settlement in a lot of cases. One, information asymmetries, like you said. Another one is the sort of psychological barrier. We tend to believe our own.
And Josh, I see that on both sides, right? I mean, I see that plaintiffs lawyers will fall in love with the case, and defense or defendants will say, I'm offended that somebody would suggest that I've done this wrong. And yeah, so absolutely, there's an element of emotion that needs to be. I'm sorry,
no, that's right. That's great. Thank you for that. And then I think there's, as you said, sort of differences in predictions, and those last two are closely connected because there's lots of empirical evidence that our psychologies cause us to have cognitive biases that make us have bad predictions, and AI can address two of those things and maybe three. So to just walk through that really quickly, if we use AI and it starts to be really reliable and it can keep track of a huge tree and assign probabilities, and that's exactly the brute force strength it has, then two things happen. One, we can get past the psychological barriers because you're not hearing it from the other side or a mediator who is in some ways paid to, maybe be unkind, to lie to you, to beat you up so that you get, because really the mediator wants a resolution first and foremost. Good mediators should do that often. So you might get past the psychology, you might get past the difference in predictions, and as I was mentioning before, you might even find out that some of those information asymmetries don't matter as much as people think. AI might be able to detect the patterns and tell you, no, 40 different law firms filed cases. I don't care what you think about the information you have. They thought that in the other case too, and you're going to be paying over $100 million to settle this case. So let's get serious. Let's save everybody money. So that's exactly right. I think it might work that way.
So I have a question. Is this sort of predictive AI, robo mediator, is this already happening, number one? And if it's not, is this sort of like an alternative that could help litigants, possibly save a lot of money rather than litigating for years if they had the option to participate in mandatory ADR and the ADR option they choose is, robo mediation? Could this be a good thing?
So I wrote an article years ago that nobody read and nobody was interested in. But I think with now, I'm going to sort of put this in my book as a discussion, because I think you've come to a great point much more quickly than I did, which frustrates me, but good for you. So yes, it's being used in a mediation setting to some extent. AI, I still think, is pretty crude at this, but it will get much better because this is in its wheelhouse. And certainly, as John said, mediators in some ways do play that role, right? There's early neutral evaluation anyway. Where I think this could go, one place that folks have not tended to go is something I called years ago expected value arbitration. What if AI not only predicted an average outcome, an expected value for the case, but the parties could sign up to be bound by that. Oh, wow. And they could introduce their evidence. They wouldn't be as nervous. They wouldn't want to hold certain things secret until trial because they're going to be bound by the outcome. They could feed in their evidence and say, no, we've got better evidence than you think. If AI gets to the point where it can do all that and dictate a really good expected value, there's lots of reasons. I wrote a much too long law review article about this, but there's lots of reasons, including risk aversion, that people might prefer an expected value outcome rather than a winner take all. The finder of fact, at least in theory, has to say up or down on a bunch of separate issues. You win it all or you lose it all, which everybody tends to dislike, right? Everybody at the day of trial, there's a reason we all settle on the courthouse steps, right? People, defense side, plaintiff side, when it really comes down to it, there's a lot of risk aversion going around. So yeah, I think it's a great idea, Kayla. I think you're really onto something.
No, but I think here's the limitation. You tell me if you disagree, but I think this is the limitation. What AI cannot do is they cannot make the judgment that, look, my defendant here pleaded guilty to a criminal cartel violation. And there is even AI, if you tell me there's a 30% chance the judge is there is a 0 chance. There is an emotional element to this. And I shouldn't pick on a judge like this, but and a hypothetical judge might just say, look, in order for me to do justice, I need to make sure this goes through. And AI, I think, would have a tough time playing poker, right? Reading the faces.
Well, so here's this. I actually think this is probably an issue that's in the wheelhouse of AI. So let's imagine your huge antitrust case, and we say, because AI is merciless, right? AI just looks at patterns. We're the ones who sort of say, like you say, I shouldn't insult a judge's. I think, well, actually, I'm not sure that's an insult, right? In some ways, we like that judges have this common sense of, wait a second, I actually should take into account at class certification, let's say, the fact that there are guilty pleas or the fact that there are not, right? It doesn't just cut one way, it can cut both ways. But here's the thing about AI, something at least as objective as a guilty plea, you may feed that in. And AI is not going to be squeamish. It's ruthless. It's going to say, actually, there's a 2% chance this class won't be certified or a 5% chance. I don't care what you say. I don't know how to look at the merits of that. What I can tell you is we've got a big enough data set, and with this high degree of statistical significance, that class is getting certified in this case because there's a raft of guilty pleas. And I don't care what judges say they're doing. I'll tell you what I predict they actually do based on robust statistical analysis. So, it could go the other way.
Yeah, I mean, and I may be in trouble because a lot of times that's the advice I'm trying to give to clients is to tell them, look, this is what we have and this is where it's going. But Josh, let me put that question to you. Should I be worried? Is robo lawyer going to replace Kayla or me?
So I think we all should be worried. And I think the reason we should worry kind of goes back to some of the things Kayla was saying before, and you were as well, but about the ethics piece. AI doesn't make judgments, but it does amplify the effects potentially of the implicit judgments we're making, but we don't even realize we're making. And that's something we have to be much more attentive to. So I think we should be worried. But I don't think in the near future we should be worried about massive displacement of lawyers by robo-lawyers or judges by robo-judges. And that comes back to the two things that I think AI is not great at, or maybe can't do at all. One is abduction, call it common sense. And the other is objective formation, or call it morality. It's lousy at common sense. It's lousy at morality. My guess is if those dominoes fall, they'll fall in that order. First, it'll get common sense, and then it'll get morality. I think the odds are it'll never get morality, at least till it's conscious. And then I don't really know whether it will get common sense. It turns out the human brain is so complicated, we don't know how to tackle that problem. But I think so. What lawyers may end up doing is, in an ideal world, they'll put aside the drudgery, hand that off to AI, and supervise it. Instead of reviewing documents, they'll be working with AI carefully to make sure that AI is doing an ethical and appropriate job of giving us information about those documents. Every time there's a technological advancement, we think there's going to be massive displacement of jobs. That's been the kind of story. And every time, the good news is the jobs don't go away. The bad news is our lives as lawyers and antitrust litigators don't get easier.
It seems that It seems like that there's a line that's being drawn somewhere, and the line kind of falls on the comfort level and the trust in the system. So if people can trust certain things, they'll probably be okay with using it. But say you have higher stakes issues, or there's a lot, someone's life is at risk, or someone's entire business is at risk. Are they really going to be able to trust the predictive ability of AI rather than going to the lawyer that they've trusted for years to advise them? I mean, it seems like that's a comfort level that humans aren't really there yet, or maybe they are, maybe they aren't.
Yeah, I think that's right. Although I think it's going to happen that we do trust AI in a profound way, because AI, if you think, take it outside of the litigation context, and then we can move back in. But when AI is going to displace doctors reading X-rays, because it turns out they're just going to save too many lives for us to go the other way. At some point, in all likelihood, self-driving cars are going to displace human drivers, and only the rich are going to be able to drive their own cars because they're the only ones who can afford the insurance, given how much safer self-driving cars are than distracted, irresponsible, multitasking human beings. So I think that that'll happen in antitrust litigation too. But having said that, I think that the tasks will be complementary, where first we don't like it at all, then we learn we don't trust it otherwise. Of course, as a lawyer, you have to rely on AI. You'd be crazy not to, just like you'd be crazy not to use modern science, which is highly technologically driven. Well, AI is going to be a bigger part of that, but we're going to want human beings to oversee it for the very reasons I said. It probably won't have common sense, and I think very probably won't have any ethics. And so those are the places that'll become more prominent, I think, for lawyers and judges. We will embrace our role as common sense machines and as, well, not machines, but that's a bad metaphor. We will embrace our role as masters of common sense and ethics or morality, because that's what will keep us from being rendered obsolete.
And I could imagine a world where we use AI, we have robo judges that help us with sort of, I will say, I don't mean this, monetary disputes. I have a disagreement about a repair job or a contract or something, and they can do the expected value assessment that you talked about very well. And I don't want to spend a lot of money on it's not a big enough dispute. Let's have somebody just figure out what sharing something bad happened. Two people need to share the cost of that. How do we share the cost of that? I could see that. Where I would get very, very uncomfortable is where you have robo judges being injected into cases that probably aren't antitrust, but that involve, well, I mean, maybe that involve individual liberty. So it could be an antitrust criminal case, or a case that involves important rights, civil rights, voting rights, individual rights. That's where I would get uncomfortable with robo judges.
I agree. And I think even within antitrust, I think that is true, because I think you're identifying this important distinction. I shouldn't call it sharp because it's actually blurry. Sometimes litigation is just about dispute resolution and efficient dispute resolution, and nobody really wants to change the law. They just want to resolve a conflict. And I think that would be most comfortable for use of AI. Sometimes we're trying to change norms. We're trying to change the law. We want judges to make framed value judgments, including in antitrust. There are important principles at stake. And we want moral judgments or judgments about political justice. In antitrust, they tend to be technical, about efficiency and things like that, but they're still value judgments. And then we want a judge who's capable of making those judgments involved. And I think one of our big responsibilities as lawyers and judges is not to get so dazzled by the technical virtuosity of AI that we lose sight of the implicit moral judgments that are being made and defer when we shouldn't. So I think that's crucial. Exactly.
It's funny, Josh, and I think we're running short on time. I want to make this one comment and see if you get your reaction to it. I don't know how many 100 years ago there was a decision to move to a world where people would be evaluated by a jury of their peers. And I think what you're talking about is exactly the reason why. In some ways, the judges of that point were the robo judges, and you wanted the jurors to be to sort of be evaluating your rights that way, and maybe to nullify something they thought wasn't right. And I think that's ultimately the same sort of thing that I see happening here, where we're all a little uncomfortable with a robo judge that would nullify, or that wouldn't be capable of nullifying something that would cause a great wrong.
Mm-hmm.
That is such a good point. I may use that someday and pretend that I had that insight myself. I think that's so interesting. I think that's right in some ways. Like, what does the jury do? And I think the answer is we're pretty darn democratic about our faith in jurors having common sense and making value judgments. And where judges are on the firmest ground is really about technical matters. They're not probably superior to our peers, or we don't think they are in the U.S. system often, about common sense and value judgments. And so it's an interesting point. I think it gets more complicated. We'd have to really think about, but it's a great place to start with an analogy.
Okay, well, this has been a fascinating chat, and let's stay in touch. I think we would love to keep talking to you about this as issues arise. But I'd like to shift gears a little bit and ask you, Josh. You have had a number of different roles in your profession and in the antitrust world. You've been a law professor. You've been a plaintiff's advocate. What advice do you have for young lawyers that are looking for a fulfilling career? Any suggestions? What should they do? What should they be thinking about?
Sure. Well, so I think I'm going to kind of tie it into the theme of the day, if I may, and that is I think paying attention to AI, figuring out how it's growing and how it needs to be managed would create a tremendous opportunity. Because one of the ways I think junior lawyers can have really satisfying careers is to develop a competitive advantage that other folks want to hire, that partners don't do as well as even junior associates. And technology is a great opportunity for that, to figure out how AI works, how it doesn't work, what its great potential is, what its limitations are, and how to manage it. That's something that a lot of folks like me who've been around for a while, we're kind of, I'm an old dog. I don't want to learn new tricks. So if you can come out of law school with some of those new tricks and you can offer them up and you can kind of tell me the bottom line, I think that can be fascinating, valuable, remunerative, meaningful, all of that. So that's what I would say.
It's interesting because many, many years ago, as I was just starting out, somebody gave me the advice that if you want to be successful, make yourself indispensable. And I think that's what you're talking about.
That's exactly right. And I'm just offering one spot to do that now based on the way things are developing. And it's exactly right. I agree with that. Indispensable and doing something that's interesting as well. And I think this for many people, for many juniorish litigators and for law students, this should check both boxes.
Well, and then let me ask you a completely different question, Josh, which is something we ask everybody who comes on the program. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
You wouldn't know. I'll give you two things. One, I can juggle. I don't know you. Only AI could tell that by looking at me. And two, I'm the master of the bad dad joke. And so that may be unsurprising, but my daughters would be happy to testify at length about that.
Yeah, so you and I may have something in common because I regularly get the feedback that I think I'm very funny. But let me ask you about juggling. Okay, because I think this is important for me to know. Okay, so I have a series of questions, sort of like survey questions that I ask everybody who tells me that they're good at juggling.
I can juggle. I just want to be clear, Kayla, you can tell me. I think I said I can juggle, not that I'm good at juggling. So that's yes.
Okay.
Good.
Okay. So that may be obvious some of these questions. So, okay. Round objects or other objects?
Not necessarily just round, but I don't do bowling pins or anything like that.
How many objects are we talking about at one time?
Two with one hand or three with two hands. I can't do it now, but I used to be able to go behind my back, which I thought was pretty cool.
I was sort of hoping we could start talking about knives. So we can't do knives?
We can. No. I will juggle with knives, only that I will be watching the dog, taking care of my daughters, and cooking dinner with knives. So it's task juggling, but I don't think that's
juggling
life. That really counts.
Juggling life.
Juggling life. I'm juggling.
The way that sentence started is, I will juggle a knife if I'm watching my daughters. And I'm thinking to myself,
no, that I would not do.
Okay, so then I guess the next question that I typically ask about flaming objects wouldn't really apply.
Can I tell you one cool thing about juggling, though, that is sort of loosely related to all of this? If you spend a day practicing juggling, you go to sleep and you wake up in the morning and you go back to juggling, you're better in the morning than you were the day before. Subconsciously, your mind has been working on that task while you've been away from it, even though you didn't know it. Isn't that?
I believe it.
And maybe that's ties back. Yeah, it's pretty cool, huh? I think that's cool. I think it's deep. I don't know what it means, but I think it's cool.
Kayla, I have to ask you: have you? How good at you are you?
I mean,
at juggling?
I've attempted it. I mean, I could do 2 pretty quick, but when you throw in that third, it stops.
Okay, so I guess no knives or flaming objects. Okay,
It's just practice. It's just time. That's all it takes.
all right. Well, let's go to our final segment that we call the Curious Hat.
And now it's time for the Curious Hat.
Okay, in my right hand, I have a series of questions. Now, when we're together, we typically have an actual hat. In the actual hat, there are actual questions. And I hand you the hat. You pull the questions out of the hat. They're on index cards. But since we're not together, I have a list of the questions in my right hand. I will ask you to choose a number from 1 to 25, and I will read you the question that corresponds with that number.
I'm tempted to protest because I'm a big Harry Potter fan, along with my daughters, and so I want a sorting hat involved in this. But okay, I'll go with number 14.
Okay, number 14. Okay. What did you, I'm sorry. What is your favorite thing to cook?
That's a good question. I would say right now my favorite thing to cook is gnocchi. And I think it's my favorite, especially really cheesy gnocchi, because my girls love it. So that's really satisfying.
So gnocchi with a G, sort of the potato pasta, yeah. And now you make that from scratch.
I don't. You know what I do make from scratch, and this would be up there, is crepes. I became a crepe maker, and on a weekend morning, my girls often will have crepes. And so that I made from scratch. I eventually learned how to do that. It's pretty simple.
Okay, and then I think I can ask you this question. Tater tots, French fries, or onion rings?
So I was told that this show was not going to get political. But okay, if you want to go there, I'm going to say onion rings.
There's no wrong way to cook a potato. Can I just say that?
Actually, because I do most of the cooking in my household, it turns out there are some wrong ways to cook a potato, but I try not to repeat that. Yes.
And with that, I think we have come to the end of our episode. We will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust.